Hello, and welcome back to Chapter 10. Still talking about the HIPAA privacy rule. We're starting on the bottom of page 218 with section 4. This is the longest section in the chapter, and I want to keep it short and sweet, but that's probably not going to happen because there's a lot of content to discuss here. I'm going to aim for 45 minutes and hope I can stay under that. All right, but the first part of this chapter, we get into the three privacy rule documents. So, the first section, we're going to talk about these three documents, and then we're going to get into some more disclosure pieces when we're talking about when authorizations are required, when you can release information without an authorization, when the patient has a chance to choose not to have their information released, and when the patient has no control over whether their information is released. All right, so our first document, before we get into the documents, look at page 219 and look at table 10.1. This is a great little reference here that starts talking about the three documents, and it's kind of a comparison. So it talks about whether or not they're required, what their requirements are concerning treatment, payment, and healthcare operations, PHI that the document addresses, whether it's required for treatment, and then the time limit on document validity. So look at that. That's a really good option there for helping you study these documents and realizing what they're for and how they're used. Now, per the HIPAA privacy rule, only two of these documents are required, and that's your notice of privacy practices and the authorization. The consent is optional, so it is not a requirement of the privacy rule. All right, so let's break these three down. So in your notice of privacy practices, we've all seen this document. Anytime you go into a healthcare facility, especially for the first time, let's say you're a brand new patient, they are going to hand you a copy of their notice of privacy practices, and they're going to tell you to read it. And most of the time, they're going to give you an acknowledgement sheet to go along with that they have you sign. Again, acknowledging that you read or you were given a copy of the notice of privacy practices to read. Okay, so that's what this document is. We're going to get into what's in a notice of privacy practices on the next page in figure 10.6. But this document, again, has to be given to that individual at their first contact with the covered entity. So what will happen for, like, let's use telehealth as an example. If the patient is doing a telehealth visit, then they may have to mail that notice of privacy to the patient. Or if we're doing some other kind of electronically provided services, then it needs to be automatic and there has to be a simultaneously delivery of that notice to the patient. Now, in addition to them handing you a copy and saying, here, read this, they also are required to display a copy of their notice of privacy practices somewhere in their facility. It has to be in a prominent place. Maybe it's posted on the wall right beside the admissions desk, or right beside a triage room in the ER, or just hanging on the wall in the ER, but somewhere it has to be posted so that someone could go read it. And it also needs to be on your website. Now, one other thing is the receipt must be acknowledged by the individual. So I told you that they'll hand you the sheet and they'll say, okay, you need to sign this. Well, sometimes a patient might refuse, or they just don't agree, or the covered entity they were so busy they didn't give the notice of privacy to the patient. Well, that has to be documented. Whether you failed to obtain it because the patient refused or because you just didn't do it, you have to document why it didn't happen. Okay? All right, so on 220, you have the big blue box there that continues over on 221, and these are the requirements for the content of the notice of privacy practices. Now, I don't have my case studies book right in front of me, but you are going to do a case study on notice of privacy practices and the requirements. So you'll have to go out and find those requirements on the internet, and you'll read the example one that they gave you in the case study, and you're going to tell me what's missing. Now, pay attention to verbiage and what they're saying and maybe even not saying in some cases. I'm not going to take it extremely hard on you if you don't get every single thing right with this case study, but I do want you to be familiar with some of the requirements or the requirements that have to be in that notice of privacy practices. All right, so let's move on to our next document. So we have our consent. And so again, we said this one is not required. It's an optional document. And it's up to the facility to choose whether or not they want to obtain consent as part of their policy. Now, if they do, the Department of Health and Human Services basically says, they have complete autonomy, complete discretion on how they choose to design that process. Because again, it's not a required document. Now, what happens with this, if we go back to 219, is because there's no time limit on validity of the document, you have to offer the patient the choice to revoke that consent, okay? Notice of privacy practices does not have a time limit either, so it's a one and done thing and it covers forever. Anytime you ever come back into that facility, that same notice of privacy practices pertains to that information collected during that visit. Same for your consent, but revocation has to be permitted. So if the patient does consent for you to use and disclose their PHI, they have to have a mechanism to go back and say, okay, I changed my mind. I no longer want you to use and disclose my PHI. Okay, now, let's move on to authorization. Authorization is our other required document per the privacy rule. So an authorization is a written permission for a specific disclosure. The privacy rule provides specific requirements for the patient authorization forms, including elements of an authorization for release of information must contain. Now, you have 6 bullet points there that if any one of those is not present or not completed, then that authorization is invalid. Okay, so be very familiar with those. One example is unlike the notice of privacy practices and the consent, that they're valid for forever. There's no time limit to validity. Your authorizations actually have an expiration date. So that first one there, an expiration date has passed or the expiration event is known by the CE to have occurred. So if I go in and I want a copy of my records, I can put an authorization date on there for 2 years in advance. And then every time I go back into that facility, let's say I have cancer and every week I need to go and I get copies of lab, okay? So I can fill out an authorization for 2 years, put 2 years from this date as the expiration date. And so then I can go into that healthcare facility and say, hey, I need a copy of this week's lab. You've got my authorization on file. It's good for 2 years. Then they can just print that. I don't have to complete another authorization because that one is still in place for that specific information. Now, if I wanted to go in and get something completely unrelated to that, then they may choose to have me complete a new authorization form because it's not for that specific purpose. All right, so again, be sure to read through those, be familiar with those. Also, because of their unique nature, HIPAA specifically addresses psychotherapy notes. Psychotherapy notes are behavioral health notes, and we don't have a slide for that, so we're just on page 222. So they are recorded by your mental health professionals who document or analyze contents and impressions of conversations that are part of private counseling sessions. Psychotherapy notes are not part of the health record and do not contain information such as diagnoses, prescriptions, treatment modalities, or test results. Authorizations are always required for the use or disclosure of psychotherapy notes, except to carry out TPO. Now, as long as it's fulfilling a specific purpose. Now, if it's being used by the originator for the psychotherapy notes for treatment, then that's perfectly fine. There's no authorization needed. If it is training programs for students, trainees, or practitioners in mental health, then there's no authorization needed. If it is used to defend a legal action or a proceeding brought by the individual, then there's no authorization needed. Or if it is with in respect to the oversight of the originator of the psychotherapy notes. So if we're looking at a physician and they say, yes, you can use these are my notes, then that's fine as well. All right, so let's get into when authorization is not required. Now, this is where things get a little tricky here, because if you see on 222, we have uses and disclosure when authorization is not required. If you flip over to 224, we have when use or disclosure is required, even without authorization. And then we have when use or disclosure is permitted without authorization. And then we have uses and disclosures that require an opportunity to agree or object. And then we have when they have no opportunity to agree or object. So again, there's a lot of information in here. I'm going to try to break it down as best as I can for you. Okay, so the privacy rule, we're back on 222, the bottom, is specific about uses and disclosure that require a patient's authorization and those that they do not require the authorization. Okay, now the following general rule provides a starting point. So here's the general rule. Patient authorization is required for the use or disclosure of PHI unless it meets an exception where authorization is not required. And so we're going to see that on a table later on, but basically they're saying if it does not meet one of the predetermined exceptions, then the authorization has to be completed. So if we flip over, it says, stated another way, unless the privacy rule specifically mentions circumstances that do not require an authorization for use or disclosure, all other uses and disclosures require an individual's authorization. Okay, so we're kind of backing into this. So an authorization is not required only when it doesn't meet one of these exceptions. Okay. All right, so let's talk about when it is required without authorization. Okay, so the goal, again, we talked about in the beginning of the privacy rule was, on one hand, we are providing greater privacy to patients' information by not allowing others to have access to it. So that's number one. When the individual or the individual's personal representative requests access, then they can have it. So again, that was the one hand. We wanted to keep it tighter and not allow access, but we wanted to offer information to the individual. So if I go in and I request information for myself, I don't have to have an authorization, okay? I don't have to have a piece of paper saying that I, have the right to get my information. It is what it is. I don't have to have that, okay? They have to give me my information, because that's, again, the second part of that rule is they allowed patients and individuals to have greater access to their information. So they have to give me my information, and they don't have to have an authorization for it. So again, a personal representative can go in, me, a personal representative for my 9-year-old son, and get copies of his medical records, and it's not required that I complete an authorization. Now, if any of you have ever went to, let's say, the Tupelo Hospital and tried to get medical records from the medical records department, from the HIM department, you did fill out a form, okay? You completed a form, but that's not an authorization. That is more along the lines of a form for their business purposes, so that they know what they've done. They know what work they've done. They know what they've released and to whom. But that's not a true authorization. So if I go in and I say, hey, I need a copy of the op report, my 9-year-old just had a tonsillectomy last month, and I complete that form, that's just their business record, okay? I should not have to actually complete anything at all to receive access of that information. That's what this is saying. An authorization is not required, okay? Now, the second one, when the Department of Health and Human Services conducts an investigation, a review, or enforcement action, well, you have to give that information to the Department of Health and Human Services, and they do not have to have an authorization for it, okay? All right, now, coming into the next section, when use or disclosure is permitted without authorization, okay? So we get into 18 situations here where the uses and disclosures are permitted without an authorization. Okay. Now, this doesn't say required, but it says permitted. I can do it. I don't necessarily have to do it, but I can do it. Now, in addition to those two situations where the authorization is required, again, the individual goes in and wants a copy, or Department of Health and Human Services wants a copy. Those are required. Now we have the situations where it's permitted. So these situations are listed in figure 10.8. So that is where I want you to focus. So again, we kind of back into things again at the top. Patient authorization required. Well, anything that's not listed in section B. Okay, so it's required if it doesn't meet an exception. Then we drop down to A. Those are the ones we just talked about, the ones where disclosure is required. So again, the individual or their personal representative or Department of Health and Human Services. Now we're getting into B. This is when disclosure is permitted without patient authorization. And again, we're going to break it down into two types. The two types where there's two where the patient can agree or object. And then there's the other ones where they have no choice. There's 16 of those. They don't have the opportunity to agree or object. Okay, so back over to 224. Now, we have two examples where the HIPAA privacy rule relaxes the authorization requirement, but your covered entities may adhere to more stringent practices. So let's read through these. So example 1, hospital under the privacy rule is not required to obtain a patient's authorization before sending the records from the patient's hospital stay to a physician that's going to follow up, because again, that's for treatment purposes. Now, many hospitals, in accordance with prior policy, will continue to require an authorization, but the privacy rule does not require that. And that makes some hospitals so nuts. And I'll use Baptist as an example. At North Mississippi Health Services, if a facility contacts us and they say, we are currently treating a patient that you saw in your emergency room 2 days ago, we need a copy of their radiology results from their ER visit. Well, North Mississippi Health Services, under this example 1 here, they send that information directly to that facility. They do not require an authorization because, again, HIPAA does not require it. They have removed the requirement. But had North Mississippi Medical Center called Baptist and said, hey, we're treating a patient that you saw in your ER 2 days ago, we need a copy of their radiology results. Baptist requires an authorization. Now, again, they don't have to, but it said specifically that HIPAA relaxes the authorization requirement, but a covered entity may adhere to a more stringent practice. So that's what Baptist is doing in that situation, is they're not necessarily following HIPAA, but they're going by their own policy. And that's okay. Now, it's painful because if it's an emergency and we've got something going on and we need those records ASAP, it may take 30 minutes to go find that patient and have them sign that authorization form and then send it to Baptist. So, and then number 2, a healthcare provider under the privacy rule is not required to obtain a patient's authorization before sending records from a patient encounter to their health insurance for payment purposes. So again, I'm not having to go to each patient and get an authorization filled out to send their bill off to the insurance company. I mean, that would be absolute nuts and chaos. So what happens is, again, mostly in that general consent, they kind of cover that business there. Patient comes in, they sign that general consent form, and it says, we're going to send your information off to your insurance company, and if whatever they don't pay, then you're saying you're going to pay. So that's kind of covered there. So again, you don't have to have an authorization for treatment. You don't have to have an authorization for payment purposes. All right, now dropping down into B, we're getting into those first 2. So privacy rule lists 2 circumstances in which PHI can be used without the individual's written authorization, but they have to be informed in advance and they're given the opportunity to agree or object. And these two situations is a facility directory. So if you've ever gone into a hospital not knowing what room a patient is in, and you go to that front desk and you say, hey, what room number is Tiffany Tubb in? I'm here to visit. They tell you, oh, well, she's in 218. Okay, thanks. Well, this is that situation to where that patient has the ability to say, I don't want to be in your directory. I don't want somebody to be able to come to an information desk and figure out where I am. So this is where a patient has that opportunity to object to being part of that directory. And then the second, notification of relatives and friends. You do not have to allow that to happen. So over on 226, it gets into that information. It talks about facility directory at the top, and then it gets into in that third paragraph on that page, the privacy rule allows a covered entity exercising its professional judgment to disclose PHI to a family member or a close friend if it's directly relevant to his or her involvement with the individual or the care payment if the individual is not present. Okay, so let's say kind of knocked out cold, and then they're going out to give information or get information on me, then they're going to use their best judgment. But if I'm available and I say, I do not want you talking to my family members, I can object to that. All right, so that's our two where the patient actually has a choice. They can agree or object. Then now we have a list of 16 where they don't have an opportunity to agree or object. They're permitted disclosures. You can send the information without that authorization. Okay. Now, this says at the bottom of 226, uses and disclosures, and I'm like on the third line of that paragraph, uses and disclosures for which an authorization or opportunity to agree or object is not required. So that's our first 12. If we flip back over to our blue box on 225, that's the numbered 1 through 12. That's those. Then we got 4 more at the bottom. But those first 12, it says, which have been identified as activities that serve national priority purposes. Okay, so the first 12 serve national priority purposes. And then the 4 remaining uses for use and disclosure, they, again, are more related to your normal treatment payment operations and incidental disclosures, limited data sets, and things like that. So they're more related to the patient, not what did it say? Serve national priority purposes. Okay. All right, so let's talk about each one of these. Okay, so if we get into the 16, let's talk about it here. Here we go. All right, so here's our 12. So again, national priority purposes, we kind of get into what they call public interest and benefit situations. Okay, that's kind of what we're going to call these two. Now, number 1, as required by law. We've talked about a couple of these before. We talked about one of these in chapter 9. If a patient comes into the hospital and there has been a stabbing, or we believe that patient has been a victim of abuse, then those are permitted disclosures that we have to make required by law. Okay? So you have to report these to law enforcement. Now, we'll get more into these later, but that's the first step, as required by law. All right, then public health activities. Use or disclosure of PHI for public health activities serves as purposes as preventing or controlling diseases, injuries, and disabilities, reporting disease, injury, and vital events such as births, deaths, public health surveillance, investigation, and interventions. So what a perfect time for us to talk about public health activities. You see every day the Mississippi Department of Health is publishing how many new patients have coronavirus. So that's a required reporting for public health activities, along with things like births and deaths. All right, 3, victims of abuse, neglect, or domestic violence. Now, so again, as reporting to the authorities, we also have to report. Let me go back and read the bottom of this. Although disclosures for the purpose of reporting abuse, neglect, and domestic violence do not require authorization, the privacy rule does require the covered entity to promptly inform the individual that such a report has and will be made. So this one kind of goes along with the as required by law, but this one is more geared towards the abuse, neglect, and domestic violence. This one's not necessarily like the gunshot wounds and stabbings and things like that. All right, number 4, healthcare oversight activities. Any authorized or unauthorized health oversight agency may receive PHI under the privacy rule for activities authorized by law, such as audits, civil or criminal investigations, licensure, and other inspections. Okay, 5, judicial and administrative proceedings. Disclosures for judicial and administrative proceedings are permitted in response to an order of the court. So we talked about a court order. And it says, with regards to subpoena and discovery requests, the party seeking the PHI must assure the covered entity that it's made reasonable efforts to make the request known to the individual who is the subject of the PHI. Okay? All right, now let's go over to 228. So, law enforcement. Now, law enforcement, it says, are disclosures of PHI to law enforcement officers allowable? Well, the privacy rule specifies 6 instances in which disclosures of law enforcement do not require patient authorization. Now, we got A through F here. So, pursuant to a legal process or otherwise required by law. So again, court order to warrant, subpoenas, or a summons. That's A. B, in response to law enforcement officials' request for the purposes of identifying or locating a suspect, fugitive, material witness, or a missing person. And so then they can only give out the following information listed. So name and address, a place of date and place of birth, social security number, blood type. You've got crime scenes. You may have blood, and you need to know, okay, well, is this possibly the blood of this patient? Does the blood typing match? What type of injury, date and time of treatment, date and time of death, if applicable, and so on there. C, in response to law enforcement's official request about an individual who is suspected to be a victim of a crime. Okay? And then D, a deceased individual when they suspect that death may have resulted from criminal conduct. E, to the law enforcement official when the covered entity believes in good faith that the information constitutes evidence of criminal conduct that occurred on the covered entity's property. And then the last one, to the law enforcement official in response to a medical emergency when the covered entity believes that disclosure is necessary to alert law enforcement to a commission and nature of a crime. Okay? All right, so that's how we have to, with no authorization, we can give information to law enforcement. All right, now we're getting into decedents. Decedents are patients that have expired or died. So HIPAA privacy protections survive an individual's death for 50 years. Okay? Nonetheless, disclosures to a coroner or medical examiner are permitted in order to identify a deceased person, determine the cause of death, or accomplish other purposes required by law. It says, in accordance with applicable law, disclosures to funeral directors are permitted as necessary to allow them to carry out their duties with respect to the decedent. So, what that's saying is that if a patient has been dead for over 50 years, then their information is no longer protected by HIPAA. But up until that 50-year mark, that information is protected. But You have those certain instances, coroners, medical examiners, funeral homes, that you can give out the information without an authorization. All right, number 8, cadaveric organ, eye, or tissue donation. So if PHI can be disclosed to an organ procurement agency or another entity to facilitate the procurement, banking, or transplantation of cadaveric organs, eye, or tissues. So again, no authorization required for that. Next, research. Privacy rule permits a covered entity to use or disclose PHI for research if approved authorization waiver or an alteration or other exceptions are met. And we'll talk about research a little later in Chapter 11. Now, threat to health and safety. So disclosures are allowed in circumstances where the covered entity believes the use or disclosure of information is necessary to prevent or lessen a serious and imminent threat to the health and safety of an individual or the public. So think about these where, if we're at school back on campus and we hear that a patient has escaped from the North Mississippi State Hospital. That's the behavioral health institution right over there on Briar Ridge Road. Information needs to be given out for that. There's no authorization required for that. And then if they feel like they're trying to apprehend someone who has caused harm, then there's no authorization required for that. All right, number 11, essential or specialized government functions. So there's a number of instances with regard to specialized government functions where uses and disclosures are permitted without authorization or opportunity to agree or object. It says most of the time these are involving release of information regarding your armed forces personnel for military and veterans activities, for purposes of national security and intelligence activities, for protective services of the president, and for public benefits and medical suitability determinations. Okay, and then also in that second paragraph, it talks about disclosure of an inmate's PHI to correctional institutions or to a law enforcement official who has custody of that patient. So if a patient was shot, but they got to go to jail, then we can release that information to the jail about what happened to them and what required care they need, or whatever. That information can be given to them. All right, and the last one of the 12 public interest and benefit is workers' compensation. So if you have a work-related injury or an illness, then there's no authorization required for them to permit the disclosure of that PHI. All right, so our last four, which we don't really have a slide for, but the last four, they're specifically categorized as uses and disclosures for which authorization or opportunity to agree or object is not required. And so again, we talked about these: treatment, payment, healthcare operations. Number 1, you don't have to have an authorization from a patient to go in and read a progress note or to read a medical order by a physician to give them a med. You don't have to have an authorization for that. All right, disclosure to the subject, individual patient, and then incidental uses and disclosures, and then a limited data set, which we've talked about limited data sets before, and we're going to get a little bit more detail over on 230. Now, so we already talked about the first two, okay? First two, if we are, again, treating the patient, trying to get paid for that care, or we're just doing our normal healthcare operations, no authorizations required. If we are disclosing information to the patient, we've already talked about they don't have to have an authorization if we're giving them their own information. But the next one, incidental uses and disclosures. Okay, so incidental uses and disclosures occur as a part of a permitted use or disclosure and are a component of doing business, okay? Anytime you've walked into a doctor's office and you've signed in that you are there, and then you've had a nurse open another door and call out your name. That's an incidental disclosure. It's just a simple part of business, and it does give out a name, but it's part of their healthcare operations. They don't have a better way to do it. I mean, maybe they give you a number, and then, when it's your number, they call your number. But that's complicated. So they may call your last name, they may call your first name, whatever. That's an incidental disclosure, but it's part of their business practice. Then the second one is a limited data set. Now, this is PHI excludes most direct identifiers of the individual and the individual's relatives, employers, and household members, but it does not de-identify the information. Such PHI may be used or disclosed without the patient's authorization or the opportunity to agree or object, because it's usually used for research, public health, or healthcare operations. Okay, now last, we're getting into redisclosure now. Patient information is often created by a healthcare provider and assimilated into another health provider's records. Examples include copies of reports sent by a physician to a hospital upon patient admission, or a patient's hospital records sent to a nursing facility for that patient's follow-up care. So this happens every day. Again, we've talked about transfers in the past. So let's say a patient goes into the hospital in Pontotoc, and they go in, they get stabilized, and they're shipped to Tupelo. Well, Pontotoc's going to send records. West Point's going to send records. If a Baptist facility sends someone to North Mississippi Medical Center, they're going to send records. If a patient is being transferred somewhere else, information is going to go with that patient just so we can continue the care of that patient. We need to know what happened. We need to know what's been done to ensure that that patient still receives the proper care. Now, redisclosure is disclosure by a healthcare organization of information that was created and received from another entity. So again, what happens is a patient comes in from Baptist and they send medical records with them. And at North Mississippi Medical Center, we would scan that in to the system, and it became a part of their record. If we use that information to take care of that patient, then it now became a part of our legal health record. And so the next time someone came and requested that patient's medical record, and they wanted the entire record, we would send our information along with what we received from Baptist. That is redisclosure. We are disclosing information that we received from another facility. Okay? Now, it says Department of Health and Human Services Office for Civil Rights provides guidance stating that it is permissible for a provider who is a covered entity to disclose a complete medical record, including portions that were created by another provider, assuming that the disclosure is for a purpose permitted by the privacy rule, such as treatment. So as long as you are staying within those privacy rule guidelines, if it's a release for treatment, payment, or healthcare operations, then you are covered by HIPAA, and that redisclosure is allowed. Now, appropriate redisclosures include those that facilitate patient care. Again, it's always about continuity of care for your patients. Are disclosed only after a patient has been encouraged to first attempt to obtain records from the originating facility. Are disclosed to comply with the legal process, or include only information contained within the designated record set. Now, further, when testifying as to the authenticity of redisclosed health information, it is necessary to state that the information was received from another organization via usual business practices, that the information was received in good faith, and that testimony regarding the record-keeping practices at the organization that created the records is not possible. So again, we talked about that in one of our case studies in the past. We can't say that the information was created in the normal course of business, but we can say that we received it in good faith in the normal course of business. All right, so let's do check your understanding, and then we're going to cut this one off. All right, so number one of the 12 public interest and benefit exceptions to the authorization requirements is disclosure to organ procurement agencies. That is true. We talked about eye, let's see, cadaveric organ, eye, and tissue donation. So anything there is one of the public interest and benefit exceptions. Number 2, the HIPAA consent explains an individual's rights and the covered entity's legal duties with respect to PHI. That is false. If we go back to our handy dandy table on 219, that is not our consent. What is that? That's going to be our notice of privacy practices. All right, number 3, per the HIPAA privacy rule, patient authorization is required for the use or disclosure of PHI unless it meets an exception whereby authorization is not required. That is true. So again, we're backing into it. We're saying that patient authorization is required unless it meets one of these 18 things. Okay? All right, number 4, incidental disclosures require a written authorization from the individual. That is false. Incidental disclosures is one of the 4 at the bottom of our list, and it is not, again, I'm not authorizing them to call my name in a waiting room at a physician's office. That's silly. And then number 5, although an individual must verbally agree to be included in the facility directory, written authorization is not required. Believe that one is true. You do not have to have written authorization. But let's go back and take a look at that and see. All right, so if we go back and we look at page, page 226. Get into the facility directory. Once the patient or individual has verbally agreed, the privacy rule makes provisions for the facility to maintain in its directory the following information about an individual. And so it does not say anything about having to have that written authorization. So if the individual verbally agrees, written authorization is not required. That one's kind of difficult to understand, but if y'all have any questions about this section, I know this was a lot of information, and I know some of these are just kind of tricky, and some of them kind of just work together hand in hand. Our law enforcement and the required by law and the victims of abuse and neglect, all that information just kind of repeats itself in some ways. So again, happy reading, happy studying. Again, if you have any questions, please feel free to email me or get with me in the group me, and I can help answer any questions that you may have. So we will finish up the last section this week, and we'll be ready to test next Thursday, I believe. So again, happy reading and happy studying.